Good afternoon. Thank you all for joining us for the final session of the day, our ethics session. We have William Bill Thomashower, who is counsel at Pryor Cashman and always gives us insight into what attorneys are doing wrong, particularly at the USPTO. So we look forward to that presentation. And then after that, we have Aisha Cassis, who is Deputy Executive Attorney at the DC Board of Professional Responsibility. And so she will tell us what the rest of the attorneys are doing wrong in DC. All right, so thank you all for joining us for the last session of the day, ethics. And with that, Bill, you can take it away.
Just show me where do we start with this?
You just changed it.
Just left and right after that, right? Yeah. Okay. So thank you very much. I'm going to sit here because as I commented to the audio engineer in the back, when I sat in the fourth row and people were speaking quietly, with the mic over here, I couldn't hear them. So I'm going to sit here and be more projected, so you wouldn't even need the mic. Now, this late in the afternoon program is our ethics program, and Aisha and I have to do different aspects of the ethics, which is good. My big concern that I focused my paper on, you see it on screen, is ethical considerations of attorneys using artificial intelligence to in litigation and USPTO proceedings. And the springboard for this is absolutely the New York Times article that came out after two attorneys who were personal injury attorneys for plaintiffs brought a federal case on diversity, I believe, and against Avianca, and they used ChatGPT to find an answer to some legal point, and they put it in, but they hadn't even read the cases. And this was the first case where that was done, apparently, and it was so outrageous that it made the Times, and Judge Castell, who I've been in front of in the Southern District of New York, correctly sanctioned those attorneys, I hope as much to make the point and make a lesson that you can't do this. So first, a little the background here on AI. So we'll slip through some of these slides that we have. So there's that. There's my disclaimer, which this is just my opinion, not my law firm and not IIPSJ. Now these slides are very thick, and it's sort of like Ian Ballon this morning doing his copyright slides. You can't sit here and read these. We'll run out of time. So I'm just going to try to summarize sort of what's here and get you through it. So what this slide talks about is what is this generative AI? It's a subset of artificial intelligence that uses algorithms and techniques to generate new data by recognizing patterns and making predictions based on existing data. You have to be very careful to understand how this technology works, okay? Professor Jamar discussed it with me this morning after he read my paper, and he said, Bill, when you say predictive, it's not predicting like you and I can predict. We can predict the weather based on data. We know a storm's coming, or we can predict what the Supreme Court might do in a case because we know the Supreme Court justices, what they've done in the past. So we can make these nice predictions. We are using our rational intelligence to do that. The machine is not doing that. The machine is not a person. It's got an algorithm that has a tremendous language base, and it just looks for the words that you're asking it in that language base, and then tries to predict based on the language that you're using what the other words would be. And it's because of that predictability, in fact, that creates what they call hallucinations. So we're going to come to that. On this page, we do say, and I say an AI chatbot, all of these things are AI chatbots, is the computer program that simulates human conversation, but it's not really human conversation. It's done through natural language processing, NLP. And the Microsoft ChatGPT came out, hit the ground running in November 2022, grew to more than 100 million users right after its launch. And that's the problem. Everybody's jumping on it and assuming it's going to give you right answers. So it stands for Chat Generative Pre-trained, next slide there, Chat Generative Pre-trained Transformer. What does that mean? It's an artificial intelligence that's a software solution that purports to understand your language, but it doesn't. It takes your words and it predicts from other materials in its data banks what words would go with that. And that predictiveness then composes, as I say here, provides data, written content as its output. But when it goes to create that output, it can take from anything, and it may even say, oh, you've asked me for a case. I know cases have to look like this. And so it created an apparent case, and it took real names of judges from those courts. And it created cases and gave it to the lawyer, said, this would be your answer. And he didn't bother to read the cases. Now, we don't have to graduate Howard Law School or my law school in New York City to know that you have to read your cases. And you don't have to work for a big Park Avenue firm or a Wall Street firm to know that you don't go into litigation and put cases in your brief that you haven't read for no other reason than maybe the case has a line that's against you, even though it has something good. I was taught as a litigator, if the case has something against you, don't use it. Pick a better case. Don't give the other side and the judge something that can be turned around on you. All right, we'll skip some of these next slides, except I will tell you that if you ask ChatGPT what it is, which is what I did, I wrote, what is ChatGPT? And then the ChatGPT gave me its own answer, which explained it's a machine. It's an algorithm. So you can read that on your own, but it's important to know that ChatGPT says, and this is a quote from Microsoft, by the way, it says, I do not have emotions. I do not have personal experiences or beliefs. I have been trained to respond based on patterns of data I have been trained on. That type of algorithm is dangerous because it'll create things from data that it has, but it's not necessarily true. It just creates. And something I just discussed off the record here with Chan Park on the preceding program, when I asked him about, in the hands of bad actors, he was able to show me on the break that actually they do have guardrails. If you ask ChatGPT, how do I create a riot or how do I rig an election, it will answer you, I cannot answer that question. But as he pointed out, that's just OpenAI and Microsoft. On this page, you see there's a whole bunch of other ones. Google Bard, which he says the bigger ones are good. Okay, Google Bard will probably protect, but there's some others here. So we don't know how those will work out. And this is all being rolled out as fast as people can compete with ChatGPT. Microsoft also has Copilot. It's all rolling out. I say here, comparison of these chatbots is beyond the scope of this paper. So, but I do mean this paper to address all of these types of problems. Next line says, well, what can ChatGPT do? This is, again, a quote from Microsoft. I don't write this stuff. I just take it right off what Microsoft says it can do. It can write essays. It can generate emails. It can answer questions. It can create content, except it can create false content. That's what deep fakes are, okay? So just because it can do these things doesn't mean it's correct or that you should use it. So you have to use these new products, these new softwares with a great amount of care. So next slide is about research. Well, again, first year law school, we teach students how to research. Back when I went to law school, we had no computers, no personal computers. You had to go to the library and use the West key number system. Okay, so I'm a boomer, I'm an old man. Okay, boomer. Now we come to the present. My kids are millennials and there's generation Alpha, which is out there now. But you all know which generation you're in. But if you went to law school more recently, you do research still by reading cases, using Westlaw, Lexis. It used to be Shepard's, and you find out what cases cite your case and you get answers. But you have to read the cases, okay? You can't ask ChatGPT to write your brief. And that's what these lawyers mistakenly did, which we're about to come to. Microsoft does mention, and I did put this slide in, other unforeseen risks of using AI for legal research is that when you ask a question, for some of the systems, the question becomes part of its data bank. So if you've got a unique legal issue for one of your clients and you put that in there, you're now possibly giving away some proprietary or even attorney-client privilege information. So I am very careful now to always not use that. There was a presentation in New York by an AI provider who said, we don't capture what you give us, so please use us, because we're not taking we're more secure. Or maybe you have to hire us, like it's an e-discovery provider, and we will be proprietary to you. It'll be a privilege. So that's something to look out for. Now on the next slide here, if I got the right one. Yes. The headline in the middle of this slide is, here's what happens when your lawyer uses ChatGPT. A lawyer representing a man who sued the airline relied on artificial intelligence to help prepare a court filing. It did not go well. And the case is Mata versus Avianca. That's a handout of the lengthy decision by Judge Castel sanctioning the lawyers for doing that. As I say below here, we review these cases. The three cases that I know of right off the top from research, proper research, not asking ChatGPT to fund, is the Mata case versus Avianca in the Southern District of New York, the Cohen case, which is Michael Cohen, and a case called Park in the Second Circuit. So the next slide here is the whole story about Mata, MATA versus Avianca. And I won't go through these. There's no time to read all these slides. Please read them on your own. The key point of Mata is that, and it's on the next page here, that in the middle of this page, it says, what happened in the Mata case was that the associate asked a reasonably complex question whether the bankruptcy law is an exception to something or other. And the result was that ChatGPT generated an answer. But the answer it generated with cases was completely generated by just pulling together words and predicting what the words should be, even to the extreme extent of creating a case name and a jurisdiction and judges who really exist, okay? And presenting that. And then the lawyers assume wrongly that, oh, this is ChatGPT. He thought it's a search engine. No, it's predictive, it's creating. And so that's called a hallucination. The quote here is from IBM in the middle of the page. A high hallucination is a phenomenon where a large language model, often a generative AI chatbot or computer vision tool, perceives patterns or objects that are non-existent or imperceptible to human observers, creating outputs that are nonsensical or altogether inaccurate. So as I try to teach the kids, not every answer is in the phone on Google. Everything you get on the internet is not necessarily true. And you have this ranging from Russian interference with elections to right down to today where they do deep fakes, people supposedly being Taylor Swift or Biden making a phone call and he didn't make that phone call. I do like the last line on this slide, which says, the IBM's warning says, AI hallucination can have significant consequences for real world applications, citing as examples, relying on these results, not just in the law, but healthcare, misinformation in news, cybersecurity, and autonomous vehicles. Imagine if AI is trying to drive your car for you and comes up with an hallucination, it'll put you through a red light, okay? They can't do that. Such AI errors can have serious consequences and undercuts the purported utility of the chatbot. So the judge finally he issued an order to show cause. The lawyers then had to hire their own lawyers to defend themselves in front of the court, which they did. They did the best job they could. They basically admitted to all the things they did wrong, almost. Judge Castel faulted the associate for claiming that he used ChatGPT to assist in his research, but actually, as the judge got on cross-examination in open court, this was your research and you didn't check it. So he said, that's sanctioned. The judge was very careful to point out that we have rules to deal with this, okay? Right now, we're starting to see, and it comes up later in the PowerPoint, a number of courts saying, oh, this is so dangerous, I'm gonna make a rule, you can't use AI. Or if you use AI, you have to do this, this, and this, check the cases. No. Do we need 50 courts in 50 states or 70-something district courts across the country to issue rules on this? Do we need the Judicial Council to issue a rule? No. Judge Castel said, we have Federal Rule of Civil Procedure Rule 11. An attorney presenting a paper states that he has done the appropriate investigation to make sure what he's stating as fact or as law is correct. And so he found that Rule 11 was violated. In addition, we have local ethics rules in New York. Just because I'm from New York, we have the New York Rules of Professional Conduct, and these are largely mirrored after the ABA. So let me come to that slide. Let's see where it is. Yeah, here it is. You see in blue on this slide, it's Rule 3.3A1. A lawyer shall not knowingly make a false statement of fact or law to a tribunal. Okay, that's it's like Rule 11. You can't make false statements to the court. The judge says right underneath that, this is from his opinion, the court has described respondent's submission of fake cases as an unprecedented circumstance. A fake opinion is not existing law. Citing to a fake opinion does not provide a non-frivolous ground for changing the law, meaning this, you flat out violated the language of Rule 11. Both the law firm and the lawyer can be sanctioned. That's the next slide. The court may impose an appropriate sanction on any attorney or law firm violating the rule. And he found it a violation of Rule 11b2. Sanctions. The judge was actually very restrained at this outrageous conduct when he says, in this slide, got the right one, X1, sanctions, is that the sanctions one? Yeah. Second paragraph, the court credits the sincerity of the respondents, that's the lawyers, when they describe their embarrassment and remorse. The fake cases were not submitted by respondents for financial gain, right? It was not done out of personal animus. It was just, he didn't say this, but it's just negligent. Respondents do not have a history of disciplinary violations, and there is a low likelihood that they'll ever do this again, right? So the court sanctioned them only $5,000, and they had to send this court opinion to all the judges who ChatGPT cited that they had put into their papers. So those judges were know they were wrongly cited. The next slide, the judge does a great job of explaining the multiple harms that can result from this type of fake opinions, okay? It's wasting time of the opposing party, of the court. It could lead to wrong results. It promotes cynicism about the legal system. This is a nice quote from the Southern District, page 18. You would think that would be the end of it. It made the front page of the Times, right? This slide here says ChatGPT continues to cause harm. How could that be? Given the wide and infamous publicity of the Matter case and that long opinion sanctioning the lawyers, front page of the New York Times and in other legal media like Law 360. You would think that the proven flaws of ChatGPT would stop other lawyers from trying to write memoranda using ChatGPT. No. The next stunt was in U.S. versus Michael Cohen. Michael Cohen had a lawyer, and he was trying to get an early release of his supervised release, and they were citing non-existent second story. Michael Cohen used ChatGPT, notwithstanding that he should have read the Times, and he collected cases and he gave it to his lawyer, and his lawyer didn't read them, and did the same thing as these lawyers in Matter. Is that mind-boggling? How do you do that? And then when it was disclosed, that lawyer was replaced by another former U.S. prosecutor who told the judge, yeah, these cases don't exist. I'm now counsel. Here's what our position is. Okay, but some damage had been done. I would have thought that's enough too. Also sort of front page stuff. No, next slide. Park versus Kim in the Second Circuit. In this case, also after the Matter decision, an attorney who had a case in the Second Circuit used ChatGPT or one of these systems to submit a false case to the Second Circuit. The date of this decision by the circuit is January 30, 2024, last month. It is very current. Court said, Second Circuit said, you are being reported to the court's grievance panel under Second Circuit Rule 46.2 for disciplinary action, and you need to provide a copy of this ruling to your client so that they know that you didn't do the right thing here. I think there's a legal malpractice claim for that. Okay, that's another point. In Park, the lawyer who was trying to explain why she relied on these cases said, well, it's in the second paragraph on this slide, said, the court, meaning the Second Circuit, should advise legal professionals to exercise caution when utilizing this new technology. Can you imagine that? The lawyer is telling the court to issue rules to prevent this? Court's footnote says, yeah, footnote 3, we've seen a couple of courts issue some new rules. And this is the quote I like at the bottom of the slide. But such a rule is not necessary to inform a licensed attorney who is a member of the bar of this court that she must ensure that her submissions to the court are accurate. Again, it's Rule 11, and it's just completely improper. It even filters down to the state courts. At the bottom of this slide, I found a case in the surrogates court in Brooklyn, Kings County, where a lawyer did the same thing, and it was, in the cases he cited did not exist, and the judge, sua sponte, said, I can't find these cases. I think this was done by AI. I'm gonna reserve sanctions for another time, but I'm not gonna look at these cases. I didn't follow what happens to him after that. In an excellent state of the federal courts article, which is, I have the site for it here on the next slide. Let's see, yeah, Chief Justice Roberts weighs in. In December, the Chief Justice issues a regular December report, what's going on in the courts. Am I taking up too much of your time? What's going on in the courts? And he commented on this AI, and he specifically referenced, he didn't say the Matta case, but he talks about it. He said it has risks and rewards. And he talks about it. It's got great potential, he says, to dramatically increase access to key information for lawyers and non-lawyers. That's DEI, right? That's inclusive. That's democratizing information and even the law. That's good. But as he says, any use of AI requires caution and humility. And he said one of AI's prominent applications made headlines this year about hallucinations. That's he's talking about the Matta case, okay? Some legal scholars have raised concerns about whether entering confidential information into AI will compromise later attempts to invoke legal privileges. That's the point I talked about. AI is actually memorizing your question. So most recently, and this is also relevant to all of you who are before the USPTO, which is big on IP. Next slide. USPTO has just issued an alert 23 days ago or so. February 6th alert says, we are aware of this problem, and here's what we're going to do about it. The alert mostly talks about, by the director, that there's enough rules out here now, and she then cites to one of my attachments, and one of the links here is the alert is a short alert, but then it attaches Kathy Vidal's more extensive memorandum on the topic. So I commend to please read the alert, please click on the link to get her memorandum, which is in here. And she just reminds practitioners, we have our own version of Rule 11, 37 CFR, Rule Part 11, same thing. And it's based on Federal Rule 11, which Judge Castell used, so it's all covered. She says that they might issue some new regulations in the Federal Register to look at. So as an ethics matter, I hope I've gotten across to you that somewhat like you can't believe everything that Google gives you back, you extra can't believe what AI chatbots give you back, not just ChatGPT, all of them, because they do a prediction which is not a human prediction. It's a statistical prediction based on a huge database and an algorithm. So always, I feel like I'm in law school 101, talking to first-year law students. Read every case that you find, however you find. You can use AI, and you might find some real cases, but read them. Do they support your proposition? Have they been overruled? Have they been reversed? Have they been questioned? Check it on Westlaw, check it on Lexis. If it has something bad in it for your case, don't use it. Find a better case. Okay, this is what I was taught in my first 5 years of litigation at a big firm. I've added now, and I'm going to switch gears for no more than 3 minutes or 2 minutes, because I want Aisha and I discussed, by the way, that I would take more of this hour than her. So don't think I'm just cramping her style. And this is something that I gave an in-house presentation at our firm on, how to prepare witnesses for deposition. And it turns out that very recently, let me get you the next slide. Get that. I'll make it work. Not going to the next slide. Oh, there we go. That's what I want. Thank you. The ABA formal ethics opinion issued August 5, 2023 is called Ethics of Witness Preparation. Now, they don't say it in here, but I think I know why they did this. We'll come to that. Anyway, they explain that in this new ABA formal ethics opinion, and they've talked about this before, what is the lawyer's role in preparing the witness? You have two sides. One, you have to zealously represent your client. So it would be malpractice not to prepare your witness for deposition. Of course you prepare the witness. You need to look at every document the witness's name is on, or the witness wrote or an email or a text, you have to know the whole thing. And you're allowed to show it to your witness in advance. It's your witness. And your discussions about that are confidential. Sometimes if you show it and it refreshes recollection under the federal rules of evidence, you may have to produce it. That's another problem. But you're not going to tell the witness what to say. How far can you go? Well, the right way to do it is you ask the witness, you play opposing counsel. Opposing counsel is going to ask you, and when you saw this memo telling you that there was a risk that the key in the ignition might shut off by itself, what did you do? Okay, you have to answer that truthfully. And I let the witness answer, and if they say, well, we committed, engineering malpractice there, no, don't say that. That's a conclusion. So you help the witness frame the best possible answer, but don't tell them to say no when it's yes, and don't tell them to say, I don't recall, when he or she very well recalls. And if we turn to the next slide here, what preparatory conduct is ethical? This comes right out of the ABA's thing. These bullet points that you see, you should memorize these when you prepare your witnesses. And this is whether it's your witness, you could be the plaintiff, not necessarily the defendant, okay? Any witness in any proceeding, if you have to prepare them ethically, you need to take the time. That's true. But here are the things you should be telling them according to the ABA. I agree with most of these. We don't have time to show you where they can even improve on what the ABA did. I want to focus on the third bullet says, explain that telling the truth can include a truthful answer of, I do not recall. Footnote 10. And here I eliminate the footnotes, except I didn't eliminate footnote 10. Next slide. Footnote 10 qualifies the instruction to a witness, I do not recall, can be a truthful answer, namely, but only if in fact you do not recall. People say, well, they don't know whether I recall, it's in my head. Guess what? It might come out that you did recall, and then they're going to get you for perjury. Don't do that. Don't say you don't recall when you actually do. Footnote 10. Telling a witness that a truthful answer, I do not recall, is an acceptable response is ethically distinguishable from telling the witness, the less you recall, the better. Does that ring any bells with anybody? Have you been watching the news? The latter statement is a statement that affirmatively encourages a witness to forget information, namely, to lie under oath. It is the ethical equivalent of telling a witness affirmatively to testify to something that is contrary to fact, see model rules. Now, the ABA opinion was careful not to make a connection, okay? But I can tell you there is a lawsuit that's been filed by the lawyer who represented Cassidy Hutchinson, saying that commentators, a particular defendant was actually Mr. Weisberg, saying that he told her to lie was defamatory. That's a case in DC pending right now. And what Cassidy Hutchinson did say is that something to the effect of they told me the less I recall, the better. So, okay, how close is that? You're not telling the witness to lie. I don't know how that case is going to come out because he didn't tell her to lie, okay? And so if somebody jumped the lie, but this ethics opinion using that language appears to be addressing this concept that in our very divisive political discourse right now, that somebody thinks they could tell a witness to the less you recall, the better. No. If you recall it, you have to answer the question. You could say yes, no, or I don't know, but you need to answer the question, okay? And that is where we leave off. That's a bonus supplement to the AI problem, is how to prepare witnesses. Please read that ABA opinion if you're a litigator, and that's good. Questions I say here, but we're going to hold questions for Aisha.
Very good.
There you go. Oh, and is that yours?
That's me.
Keep pressing the right hand button.
Okay, thank you. Well, it's my turn. I know that I'm the last woman standing between you and the rest of your day, so I will, and a cocktail, right? So I won't take up too much more of your time. I'm Aisha Cassis. I am a 2005 graduate of Howard University School of Law. Once upon a time, I used to practice intellectual property law. I've done corporate matters, litigation matters, but now, obviously, I do disciplinary law. So just a couple of follow-ups, quick follow-ups to Bill's presentation. I will say, thankfully, mercifully, we in DC have had no court cases yet involving AI issues, no hallucination case issues. I can't say that the Office of Disciplinary Counsel hasn't seen any, but so we'll all stay tuned. I should back up and give my disclaimer that all of the views expressed here today are my own and not those of my office. But I will say, I just had a conference in Long Beach. I was co-chairing our conference, the National Council of Disciplinary Boards, and we had a professor come in from Canada to speak about sort of AI issues and the cross-section between that and disciplinary law. And she echoed a lot of what Bill was saying, but two interesting pieces of her presentation stood out to me. The one aspect that we've been made aware of is the sort of the citing, artificial cases, but there's also, and so that's like a competence issue. But towards the other end of the spectrum, she talked about how easily this artificial evidence can be created using AI, and how woefully inadequate our tools, the court's tools, opposing counsel's tools might be to detect that evidence is not accurate or that's not real. So that was something that I had not considered before, and it is a risk that's coming down the line, I would imagine. Let's see. The other piece that she raised, I thought was very interesting, and it touches on some of what Bill talked about, was kind of like the early days of Westlaw. Westlaw used to be, the Westlaw and Lexis tools used to be, when I started at law school, started as a lawyer, they were very, very expensive to use. When I was in law school, we were still using the books, candidly. I do actually still prefer the books. I like to see the whole area, and then kind of once I got—
You and me.
Yeah, and then I can kind of figure out, okay, I can whittle down to my issue. But that is a very, very expensive way to represent clients. And there is an expectation. And now that Google, Westlaw uses like a Google sort of algorithm, that the expectation is that you're not going to go and spend, a whole day in the library to research some simple issue. And the thinking is that what we will see in short term, the expectation that the most efficient thing for clients, the most cost-effective thing for clients will be to use some tool like that. And quite frankly, Westlaw is a form of AI too, but there's that. Okay. So jumping ahead to my presentation, I'm just going to make a quick pitch first to those of you who are licensed in the District of Columbia. I do this every year. If you've been practicing for 5 years as a lawyer, you're licensed in DC, I really would love for you to consider serving as a hearing committee member. It's really rewarding work. You kind of it's playing a judge in our cases. And the cases tend to be very interesting, I think. Disciplinary counsel has tools to sort of handle like less sort of minor misconduct. So the cases that hearing committee members do get tend to be very interesting, and people find the work rewarding. So that's my plug. In the last few minutes I have with you, I'm just going to talk about a few fairly recent decisions that the court has handed down since the last time I was here. Okay. That's my pitch. Our rules are included on this slide. We don't follow the ABA model rules like some states. DC has their own. They're very similar, but they're not the same. Available here. And if you're interested in watching a hearing or an oral argument before the board, if you go to our website, there's a schedule of all of the upcoming hearings and arguments. And from there, you can actually, they're all streamed on YouTube. It will direct you over to one of our YouTube channels. This slide just lists out the players in our discipline system. You can see that the DC Court of Appeals sits on high, appoints the members of the board on professional responsibility. My office, the Office of the Executive Attorney, is over to the right, and we serve as counsel, sort of counsel to the board and the hearing committee members. And then you have disciplinary counsel who prosecutes the cases at the bottom left, and then the respondent on the right. Oops, okay. All right, the first case I was going to talk quickly about is In Re Paul. That case was issued by the court on April 20th of last year. The case is interesting. It involved an attorney who filed a disciplinary complaint against his own former client, who's also obviously an attorney, for violating the disciplinary rules. The client first filed a complaint against him. The respondent then filed a complaint against the client. The respondent was charged in this case with disclosing client confidences or secrets in his disciplinary complaint. Specifically, he'd argued that the client was not mentally competent to be a member of the bar and that he should not be allowed to practice. And he also claimed that the client was dishonest. As a reminder, Rule 1.6A provides that lawyers shall not knowingly reveal confidences or secrets of that lawyer's client. There's a narrow exception under that rule that a lawyer may reveal such a confidence or secret only to the extent reasonably necessary to establish a defense to a criminal charge, a disciplinary complaint, or a civil claim instituted against the lawyer. But again, it has to be really a narrowly tailored response there. Mr. Paul, the respondent, presented a number of arguments that the court rejected. He argued that Section 19A, DC Bar Rule 11, Section 19A, provides that disciplinary complaints are quote unquote absolutely privileged and no claim or action predicated thereon may be instituted or maintained. And so he argued that he was immune from the disciplinary complaint because he had filed his own disciplinary complaint. The court disagreed and held that Section 19A does not immunize an attorney complainant from professional discipline if he violates the rules of professional conduct in the course of filing or pursuing his disciplinary complaint against the attorney client. He also argued that the information was not a confidence or a secret. The court saw that as a losing argument and reminded us that Rule 1.6 explicitly prohibits the disclosure of a client's secret, which is defined as information, the disclosure of which would be embarrassing or detrimental to the client. And of course, what he included in his complaint clearly was. He received a 30-day suspension. The next case is In Re Libertelli, was decided by the court on June 8th of last year. This is a flagrant dishonesty case, the penalty for which is disbarment in the District of Columbia. Flagrant dishonesty includes dishonesty that is aggravated or prolonged. So this was an interesting case. It arose from his conduct as a party in divorce and custody proceedings over in Maryland. Over the course of a little more than a year, respondent falsified at least 62 drug test results and fabricated 5 results for tests that he never took. He also he was trying to conceal his use of drugs and provided altered or falsified financial documents to conceal the money that he spent on drug purchases and also to conceal the dissipation of the assets. Respondent conceded the rule violations, but he argued that because he was addicted to prescription opioids during the time of the misconduct, that he should be entitled to mitigation under our case in Ray Kersey. The problem with that is, unlike other states in the District of Columbia, whereas addiction to lawfully prescribed drugs qualifies as a disability that may serve to mitigate a sanction, addiction to illegal drugs does not. There are other states that don't take that position. The problem was that he had abused not only, or they found that he abused not only opioids, which were legally obtained, but he'd also been using illegal drugs. And he just couldn't prove that his addiction and his conduct were solely tied to the legally obtained prescription drugs. Respondent was disbarred in that case. The next case is In Re Soto. It was decided by the board in August. There, the respondent was suspended for 6 months for dishonesty and serious interference with the administration of justice in a real estate transaction case. So essentially, this case, the respondent was representing a client who wanted to minimize the amount of, well, I shouldn't even say that, who was unhappy with the amount of taxes that he was going to have to pay in connection with a property transfer. So after the documents had already been notarized, the respondent modified the amount of consideration on the form to cause a reduction in the taxes he would have to pay. He argued before the court that he didn't violate Rule 8.1A because his statement wasn't knowingly false. He was just oversimplifying the transaction and omitting certain details when he was responding to disciplinary counsel's inquiry. The court found that his statements were deliberately misleading and that he had used the complexity of that real estate transaction to obfuscate his conduct. And so he got a 6-month suspension for his dishonesty. In Re Blackwell is another case that was decided by the court in August. The court was busy in August, as you can see. The respondent was suspended for 6 months with all but 60 days stayed. That case was also interesting. This case involved the failure to make court-ordered child support payments and also making a false statement to disciplinary counsel in connection with his investigation of that case. And just to give a highlight of the facts, in May 2007, the Circuit Court of Prince George's County, Maryland, had issued a consent order that required the respondent to make monthly child support payments in the amount of $156. That was ultimately increased to $250 and then to $500. Respondent fell behind on making his child support payments, and the child's mother filed a complaint with the Office of Disciplinary Counsel alleging that he failed to make the court-ordered child support payments, which were up to about $50,000 by that point. And then he'd also failed to appeal in court when he was required to. In response, the respondent denied that he had ever willfully failed to make child support payments pursuant to any court order. Disciplinary counsel followed up in response to the complaint and asked whether he had agreed that he failed to make the court-ordered payments, and he said no. He ultimately conceded that his failure to make the child support payments violated Rule 3.4C, and that rule applied to him even though he was not acting as an advocate in that circumstance. And the court also rejected his argument that, he didn't have the requisite mens rea in response to in responding to disciplinary counsel's question, such that he had been provided a knowingly dishonest response. Hope that's not too convoluted. Okay. The next case is In re Wild, again decided by the court in August. Here, the respondent was disbarred for criminal theft, fraud, and forgery in violation of Rules 8.4b, which is our criminal conduct rule, in addition to 3.3A1, 3.3A4. Basically, she submitted a number of false documents and false evidence to the court and was dishonest throughout the process. This arose from her conviction in South Korea for theft on a flight leaving from Washington, D.C. to Seoul, Korea, and then her subsequent attempts to cover up her misconduct. And by the way, all of the cases that I'm discussing were included in the materials if any of these are interesting to you. One interesting fact about this case is that Maryland had considered that her criminal conviction and dismissed the case. They thought there was not enough to pursue there. The court agreed with the board that collateral estoppel did not apply to the Maryland court's decision to dismiss the disciplinary charges against respondent because disciplinary counsel had not participated in that case and was not in privity with its Maryland counterpart. The court also pointed out that the Maryland court's findings weren't owed deference due to the discrepancy in the amount and quality of the evidence and findings between the Maryland proceedings and those conducted in DC. And that there's also the board had found that there wasn't enough evidence that a prosecutor could have established that respondent had violated each of the charged criminal statutes, and the court disagreed and found that there was enough evidence. So the court agreed with the board that she should be disbarred because she committed theft and had engaged in repeated and pervasive dishonesty to cover up her criminal actions. Okay, the last case I have here is In re Dobby Taylor. That was decided by the court in December. This is one of the rare prosecutorial misconduct cases that we see involving Rule 3.8E. Rule 3.8E, in relevant part, provides that prohibits prosecutors from intentionally failing to disclose to the defense any evidence or information that the prosecutor knows or reasonably should know tends to negate the guilt of the accused or to mitigate the offense. So there are multiple levels of mens rea in that rule. This particular case involved a Brady violation. And just to point out, a Brady violation is not enough to prove a 3.8E violation because Brady is broadly attributable to the government, whereas Rule 3.8E really looks at the specific attorney's role in that matter. The attorneys in that case, the prosecutors withheld a report that would have served as evidence that a key witness had been disciplined for dishonest conduct before they testified at the trial. They did disclose the report to the court in the context of a motion in limine, but they misdescribed the conclusions within the report. They also accidentally failed to provide the court with the full report, but the court didn't take that into account in deciding whether there was a rule violation. Everybody agreed it was just an accident. There were two interesting aspects of this case, in my view. One was that although the court agreed with the board as to the rule violations, a majority of the panel found that the board's recommended sanction, a 6-month suspension, was too harsh, considering that the respondent's supervisor provided inadequate guidance and advised the respondents to take an unnecessarily risky approach without ensuring that all the required disclosures were still made. That is interesting because, you know, the rules of professional conduct apply to all of us day one when we start practicing law. If we don't, you know, if we need resources, if we need help, we have to go out and get that. But there's no exception there's no new practicing lawyer exception to any of our rules. The majority reasoned that the stage suspension was appropriate, whereas here the respondent's culpability was blunted, that's a quote, as they were not solely responsible for the misconduct. And generally, we don't see that many cases where that is a mitigating factor in terms of sanction. The second interesting point about this case was that the court agreed that respondents had engaged in reckless dishonesty in violation of Rule 8.4C. But the court said, we do not think that the respondents acted with the kind of malign intent often associated with those words. Rather, again, they were inexperienced, poorly supervised, and made serious mistakes that we have no reason to believe they will make again. And again, dishonesty is such a serious charge, especially reckless dishonesty. So to have a fully staged suspension in a case where the court is finding that the prosecutors engaged in reckless misconduct, reckless dishonesty, I think that surprised all of us. And that's the last for me. And so we will take any questions.
Any questions on either presentation? And then again, thanks to IPSJ for having us again. This is my 21st year, so I've been here as much as Latif, although I wasn't on the bus in a while. Any questions? Yes. If you got to speak loudly, because you guys don't have a mic.
So the question was, for a new lawyer, you correct me if I get this wrong, for a new lawyer, how do you keep track of what your professional obligations are, what guidance, and given that you do lectures internally, I think that's a great question for you, Bill.
Well, the first thing we do know is that when you graduate law school, there is some classes on ethics. Whatever jurisdiction you go to after law school, and you have 50 states, each state has its own rules, and you need to read the rules applicable in your state. That's really it. You don't have to start, reading ethics opinions until you have a specific problem. You can research the ethics. Ideally, if you start out, you don't leave law school and put up your own shingle, now I'm a lawyer. You start with a firm like Finnegan or someplace that has senior people who can answer questions as you go and teach you. It's like a doctor gets out of medical school. They don't go into the operating room. They have to do a 3-year residency. And then they go from there. Also, when you pass the bar exam in the state you're in, there are usually some ethics questions to get through that. Now, I take your question a little also mean when things develop, how do you? Right. Right. As your career goes forward, what do you do? I believe that it's the same concept. You should, if necessary for yourself, reread the state's rules. Certainly, if something comes across your desk that you're not sure if it's the right thing to do, seek guidance. I know in New York, for example, we have the Association of the Bar of the City of New York, just as an example, this is available elsewhere, has a committee on legal ethics, and they have a hotline. It's not binding, but if you call the hotline, I don't know if it's still operating, it was when I was on the committee, you could say, we used to take calls. We used to have people from the committee take turns fielding these calls. It's like, not the suicide hotline, but it's like, I got a problem that I just found out my client lied on the witness stand or something, what do I do? And the hotline directs you in the right way to find it.
And if I might also add, the DC Bar also has dedicated attorneys who respond to questions about ethics issues.
That's good.
We still have that. The other thing is that the rules don't always provide clear guidance on how one would respond in a particular context. One great example is the misappropriation rule. There's no mention of the word misappropriation in Rule 1.15A, for example. And so it's very important to keep up with the courts in your jurisdiction, with the court's opinions addressing particular areas of conduct. And I really think a mentor is invaluable as well, but I would say definitely keep up with the ethics opinions, the court's opinions. I mean, we've had one case in Ray Har where the attorney, one of his response to a disciplinary complaint was that, well, when I started practicing in whatever year that was, the rule was X. And then but in DC, we had a huge case that come out in Ray Mance that changed the way advanced fees had to be treated and the extent to which you had to get informed consent from your client. And it turned something that would not have been misappropriation, a disbarment offense, overnight, arguably, into, it was prospective, but into something that was a disbarment offense. So there's also, again, if you're in DC, the bar puts out tons of classes to keep you updated.
I was just going to add that in each state, you can take a continuing legal education class on ethics. Now, Nancy's trying to ask a question.
Mhm.
Right. Right.
Now, in DC, we don't have CLE. So
What do you have?
we don't have CLE in DC.
Oh, okay.
Nope. Yeah. Yeah, you can voluntarily. Yeah.
Right.
Yeah, absolutely. And to clarify, we have obviously DC bar everywhere, there's tons of CLE. We don't have a requirement that we have to meet every year.
Yeah, that's what I meant. Well, you have CLE in the sense that you
can take, yeah.
you can take a
They're
course.
readily available,
Yeah.
right?
Same thing in every other state. Yes, ma'am. Speak loudly for us because we got amplified. Can you repeat it for the audience?
I want to make sure I understand your question. So are you asking, you're mentioning the NPRE and you're asking whether we have our own set of, the rules. We have a different set of rules of professional conduct. Is that what you're referring to? Yeah, so DC does have its own. We don't follow the ABA model rules as do, I don't know, maybe a majority of the states. DC does, but they're very, very similar to the ABA model rules.
Only the bar exam,
Yeah,
only the bar exam for the state that you want to get licensed in.
Now they still have waivers. So I didn't sit for the DC bar exam. I sat for the New York bar exam.
Right.
And so long ago, it's almost 20 years. I can't remember where I took the NPRE, but I waived into the District of Columbia with my New York license. I don't know if that answers your question, but I can't remember. I don't think you have to take a different NPRE for each jurisdiction. I think if you get a high enough score on it, I don't believe so. Yeah, so is the NPRE score transferable? I won't, it's been so long.
For those who are remote, they're talking about Maryland now.
And the NPRE process.
And the NPRE, right. Multi-state professional.
It's been a long time. I apologize. I mean, the committee and I sit inside the Court of Appeals, and I think our Committee on Admissions is right next door. So they're great about answering questions. I can't, but I don't remember taking it more than once. Oh, sure.
Another question. That's a good question. You know, it ties in with, you know, the millennials know how to do long division, because now it's, you have a phone, it doesn't, okay? It used to be a skill that was taught and learned, and has to be an advocate. How do you write a convincing, powerful brief that's not too wordy, that makes the points, that has them in the right order? It is potentially ChatGPT could do that. I wouldn't trust the cases that they cite, but you could ask ChatGPT to do that. And I understand that there's an abuse where students and doctoral students are asking ChatGPT to write their papers, okay? Assuming you check the data, you could get clean data, but how it's presented, maybe ChatGPT is finding some other brief that was written to the Supreme Court 4 years ago in a similar issue and quoting from it, probably well written to the Supreme. So I would say you can use it for that purpose, but be thoughtful about the longer term goal to teach you how to be able to write it. If I didn't have my phone, I can actually divide 131 by 22 and I can give you an exact answer, okay? I know how to do that. But that's called long division. But the same idea here, you want to learn the skill of being an advocate, because sometimes you might have to be on your feet and you don't have AI ChatGPT to answer the judge's question. So be prepared, you know, in court, not just about brief writing, but on brief writing, yes, you can get some help from it. Just be careful if it's factual, purporting to be factual, you have to check that. That makes sense? Is there a code, Professor or Tasha, is there a code for this? Oh, they just put it up. I'm
Okay.
sorry. So the code for this session is section number 6. Oh, you lost it now.
Oh, did I?
No, he put it up.
It's protecting people is the code. I was trying to go back.
Protecting people. Session number 6, the code is protecting people. If you stay till the end, you're in business. And I guess that is the end for us, right?
Thank you.
Thank you, Tasha.
Thank you, thank you.